Eitzen Show. I'm Melinda. We are so fortunate today to have Robert Epstein with us. He's a family lawyer like me. Welcome, Robert.
Thank you, Melinda. It's great to be here.
I'm so glad you're here. So, this was a legislative year, right?
Yes, it was.
And how often does that happen?
Every 2 years. So, in odd numbered years like 2023, we have a legislative update with new statutes in our family code.
So, part of our job as lawyers, we have to keep up with the law changes, right?
That's exactly right.
And we're going to talk today about what changed that affects family law. So, one area where they were focused was on protecting people.
Yes.
Definitely good to protect people. And one area was in protective orders. And there's two types of protective orders. There are criminal protective orders that the police get, but there's protective orders also available under the family code.
Yes, that's correct.
So how did that change? What's the difference now?
So, the biggest difference is that in the past, when the burden was to prove that family violence has occurred and is likely to occur in the future, you now no longer have to prove it's likely to occur in the future. All you have to prove to get a protective order to protect you or your child is that family violence has occurred. That's all you have to show. And so that's a significant change because essentially it took away the burden to prove two prongs or two elements to be able to qualify for a protective order.
Protective order is a big deal, right?
Yes, yeah. It means that you can't own a gun. It means that you have to stay a certain minimum distance away from the protected person or face criminal repercussions, among other things.
And it doesn't just affect the perpetrator that stay away from this person. That could be handled with an injunction. It's a bigger deal than that, right? And
yes,
it could affect their job status. It might affect their ability to get a job in the future. So not to be taken lightly, right? It's a big deal.
Yes, very much so.
And difference between a protective order and an injunction, if somebody does come within 500 feet and the injunction says that and the protective order says that, what's the enforcement difference?
Sure. So with respect to a protective order, the person who is violating the protective order can be arrested for violating the protective order. The person who is violating the injunction can be held in contempt of court, but not until there's notice and hearing. So that requires an actual evidentiary hearing before a judge in order to be punished. Whereas with a protective order, you don't have that requirement for enforcement. You can go to jail if you violate it.
They step on the lawn, police can come take them.
That's correct.
Okay, so you mentioned the difference now is we no longer have to show violence is likely to occur in the future.
Correct.
That was difficult to show in some cases. Like, how do we talk about what's going to happen in the future?
It was, and it was actually the best defense when you actually represented somebody who was accused of committing family violence. You know, that this person is not likely to commit family violence in the future because they're doing A, B, and C, getting counseling, going to recovery, whatever it may be.
Just the fact that they weren't living together anymore.
Right. For sure.
Really lessened the chance of family violence occurring in the future. They don't have physical access every day to this person anymore.
That's correct. And especially if it was just like an isolated incident, you know, like a one-off. You know, it was harder to prove that family violence was likely to occur in the future if it was, for example, a long marriage and this incident of family violence was you know, once in, say, 20 years. That was the best defense for the alleged perpetrator, and now that's no longer available.
So now I think, and see if you agree, that the focus and the fight's going to shift to the definition of family violence.
That's correct.
So what is the definition of family violence?
So family violence is an act that intends to place a person in fear of their bodily safety, or that actually results in bodily harm to that person. It could actually be a threat that reasonably places that person in fear of his or her bodily safety.
So it doesn't have to be you put him in the hospital.
That's correct.
It could just be threatening, I'm going to kill you.
That is 100% correct.
So that's a big difference, right? Putting somebody in the hospital is very different than I'm going to kill you said in haste. I'm not saying people should say I'm going to kill you.
Right.
But I think most people could see a difference in that.
Oh, absolutely. And there's no difference in the family code among the types of family violence. There's no different levels of degrees of family violence. It's all under the same definition. So if you have one incident of making a threat that reasonably places a person in fear of their bodily safety, that by definition is family violence that could result in a protective order against somebody for 2 years.
And it says the judge shall
That's correct.
give a protective order
Yeah,
if they find that happened.
They're entitled to one. That's correct.
So it's a big deal. People
Very
need
big
to be
deal.
aware that they cannot run around just saying whatever they want to say.
Right. And you know, people can sometimes say things in jests. People can sometimes, you know, not intend for something to actually place someone in fear of their bodily safety, which is very subjective. So yeah, I mean, everybody needs to be very careful and should be careful anyway, but especially now.
And texting, there's so much communication by text now. Younger generations, they text everything.
Yeah, it's easier to prove, and I mean, you can easily record somebody on a smartphone nowadays. So you know, it's a lot easier to prove what somebody said than it once was.
And it's legal in Texas to tape record a conversation if you're a party to it.
That's correct. You just have to be a party to it. Right.
So if you're in the house with your significant other and they're losing their mind, telling you what's what, and you're fearful, you could tape that.
Right. If you're in a marital dispute, an argument, absolutely. And as long as you're, you know, there, present, participating in the conversation, you're the unilateral consent that is required to record the conversation. You just have to have one party's consent. The other party doesn't have to know, and you can be that party who consents.
And that's good evidence. I mean, sometimes it's such a he said, she said,
Of course.
right?
Yes.
And most violence happens in the privacy of people's homes.
Right. That's
Nobody
100%
else
correct.
is there.
That's 100% correct.
So, you know, you hate to tell your client, hey, record it next time, because you hate that they have to wait till next time.
Right.
But record it next time is
Well,
not bad advice.
Absolutely. And the reality of the situation is that our courts, as you know, Melinda, are reactive instead of proactive. I mean, most of the time anyway, that, you know, nothing's going to happen unless something has happened. And
Right.
So yes, I mean, you need to make sure that, you know, you're doing what you have to do to protect yourself and to show the court why you need what you're requesting.
Of course, best advice is get out. Like if you're
Right.
to the point that you have to record your spouse,
Right.
get out.
Right. If you're legitimately afraid of your bodily safety,
Yeah.
you should probably leave the house. Absolutely.
And that's one test. Like if somebody calls me and they say, "Oh, I'm afraid," and I say, "Get out," and they're like, "I'm not getting out," you know.
True.
Well, how afraid are you?
Right. That's a good litmus test.
But we do have the cycle of violence, of
Yes.
domestic violence, where sometimes people are not, like what I just said sounds so logical. But when somebody is in the cycle of domestic violence, they're not always logical.
No, that's very true, and it's very unfortunate to see. And there are so many other factors that can be considered as well, like financial support. Oftentimes, victims of abuse don't have control over their assets or income, and so they don't have the financial means to be able to actually get out. It's easy for us sitting here to say that, but the reality of the situation might be much different for that person.
Yeah. So they need resources.
Absolutely.
One of the changes in this legislative session is somebody in the government, some organization has to make a pamphlet now that the police can hand out, that medical providers can hand out, that tells people resources that they can find when they are victims of domestic violence. And there's studies that show if somebody is handed something on a piece of paper, they're more likely to get help.
I believe it. Yeah. Access
So-
to information.
We have to, try to break the cycle.
100%.
Okay, so another area that's kind of a protection area is the possibility now of having a standing order, and you can explain what that is, or in the protective order, language about tracking and following.
Right.
Tell us about that.
Sure. So now you can get an injunction or a restraining order without an affidavit, without requiring proof that prohibits somebody from following you or having somebody hired to follow you, or that prohibits somebody from tracking your vehicle. Even if that vehicle is titled in your spouse's name, they can be prohibited from tracking, placing an air tag in that vehicle, which is actually lawful if they're on the title to the car, But now there is a statute that says that essentially upon request, without an affidavit, anyone can get a restraining order that prohibits the other spouse from doing these things. And that's a huge development in the law, because in family law we've had private investigators, that do surveillance, and now that might not be the resource that it once was.
I tell you, when I heard that change, what I immediately said is, are we in America?
Yeah.
I mean, how can you not be allowed to have a private investigator follow someone? This is like freedom of movement. Don't we have a right to develop our case? What if they're doing really bad stuff?
Right. Yeah.
What if they're endangering the child? How am I going to prove it now if I can't have somebody follow them?
Right. I mean, there are significant repercussions as a result of this new statute, without question.
So it's not automatic. They have to ask for it, or we don't know if one of our counties will put it into the standing order. What
Correct.
is a standing order?
So a standing order is like a temporary restraining order, like a temporary injunction that prohibits parties in a child custody suit or in a divorce from doing certain things. And when you file a suit, for example, in Dallas County, where we are now, there is a Dallas County standing order that applies to any child custody suit or divorce in Dallas County. And it's a list of things that are prohibited, that the parties are prohibited from doing. And it automatically applies to the person who files the suit, and then to the person who is served with the suit after they receive notice of it, that these things are orders of the court that say what you cannot do and what you can do.
So the judges are going to have to decide if they add that.
Correct. And many of the things that are in the family code that you can automatically get without an affidavit, such as now prohibiting tracking somebody or following somebody, are already part of the standing order. So it's to be determined whether Dallas County and some of the surrounding counties that have standing orders are going to be following that and adding that to their standing order.
You know, for some reason, my reaction to the tracking, I kind of get that. That's back to the protective piece.
Sure.
That's not a professional.
100%.
That's an individual putting a tracker on your car and to go follow his wife or her husband and make a scene at the boyfriend or girlfriend's apartment and beat him up.
Right.
Like, I see that.
Right.
Don't put a tracking. I'm with him on that.
I agree.
But a PI is not a danger.
No, it's a licensed professional.
Right. So to me, that's a world apart. And that's the opposite, which is we're trying to protect children.
Right.
Maybe they're taking the child into a dangerous situation, around a dangerous person, around someone they've been court ordered not to have around that child.
Sure.
How do we prove that now?
Well, you hope that this injunction is not part of your case. It's going to be a lot more difficult to prove. Child statements oftentimes are considered hearsay and not allowed as evidence in a child custody proceeding. There are exceptions to that, of course, but yeah, it's gonna be interesting to see the implications of this.
Okay, so you led us with your talk about children's interviews. That leads us into the child custody evaluation statute. So there was a couple of changes to that.
Yes.
And tell us a little bit about that.
Sure. So a couple of things with the child custody evaluation is now there's a requirement that the interviews with the child or children in a child custody evaluation must be recorded by audio-visual recording. That is significant because in the past, children interviews by child custody evaluators were not recorded, or at least it wasn't required to be recorded. And I think it was best practice probably for most evaluators to not actually record the child interviews because they were concerned about a parent getting a copy of their file, which would include a copy of the recording. And the reason why that's significant is because you don't want the child, to be essentially the victim of one parent saying, "Hey, I heard you on this recording," and just browbeating them over it. So, now that option, unfortunately for those types of parents, is out there with the requirement that the child custody evaluator record these interviews with the children.
And it's going to be video and audio.
Correct. It says audio visual, so you have to assume that means a video and audio recording.
They'll be wearing like a body cam, or they'll have to be in a room where they have the camera.
Right.
I think I see the reason for it in the sense of lawyers should have a right to know what the proof is.
Sure.
Right? It's kind of like before, this evaluator didn't even have to tell us exactly what they said. So as a lawyer, how do I fight against mystery proof?
Sure.
So in that regard, I see why, as part of the case, the lawyers would want that. But you wonder if a teenager who knows they're being recorded is really going to be frank and earnest with a custody evaluator.
Yeah, that's another very important consideration that you bring up.
It's obvious it's not private.
Right. Right. I think that's a very good point.
And you know, some judges can interview kids too,
Yes.
right? It's a separate issue and it's not part of this custody evaluation, but a lot of them don't want to have anyone in there or a court reporter. They
Right.
can. And for the same reason, they want the
Absolutely.
child to tell them the truth.
Right. Absolutely. Absolutely.
So you wonder if it might help in some ways. It would certainly protect against some rogue custody evaluator.
It would.
But it might hurt getting to the truth.
Yeah, I mean, it may be well intended, but I think in practice, it's going to have more negative consequences than potential benefits.
I think we've had over really several years now, the child custody evaluation statute has gotten meatier and meatier.
Yes.
More and more rules about who can do it, how do they do it, which again has some good points. Is it's not just somebody making stuff up,
Right.
but it's made them take longer and it's made them more expensive.
No doubt about it. Yeah.
So you wonder if this is just another piece that's going to make people say, forget it.
Yeah, and then it becomes harder to find good people to actually do these evaluations.
Oh, yeah.
You know.
Then you just say, just put your evidence onto the judge. Forget the child
Right.
custody evaluation.
Yeah. No. And the other thing, you know, with the child custody evaluation in this new legislative update is that the legislature has made it clear that we can now hire a rebuttal expert to challenge the child custody evaluator's recommendations. In the past, in some cases, these experts were disqualified or I guess removed, excluded from testifying because they did not actually do a child custody evaluation. And the Family Code makes clear that in order to give opinions, recommendations on conservatorship, possession, and access, you have to actually meet the elements of a child custody evaluation. You have to do a child custody evaluation. So these rebuttal experts who were hired by one side who wasn't pleased with the child custody evaluation to challenge it, in some cases had been excluded from testifying. And now the Family Court or the Family Code makes clear that under the new legislative update, you can hire a rebuttal expert who can challenge the qualifications of the evaluator or the methodologies of the evaluator. As long as they don't give an opinion on conservatorship, possession, and access, they're able to testify, which means that the ability to essentially provide some checks and balances on the child custody evaluation has become a little bit better as a result of this legislative update.
Yeah, I like that. I mean, I think that's good for the trier of fact, whether it's a judge or a jury, to have somebody else say, look, they didn't do XYZ, or hey, what about your qualification? Are you really qualified?
Sure.
And I guess as lawyers, you could make argument about that before or cross-examine the person, but this is another professional who, you know, in theory, has the same type of qualification or better, who can say, ooh, maybe they should have done XYZ.
Right. Yeah, it's you know, basically peer review.
Yes,
right?
yes. So I think I like that change.
Yes, me too.
So it's a little bit easier now to adopt your stepchild.
Yes, that is correct. For step-parent adoptions, they don't require the social study or the evaluation for the adoption placement anymore, which is a good change, and I think that will hopefully encourage step-parent adoption in cases where you have a healthy marriage between a biological parent and a step-parent, and you know the other biological parent either might be deceased or maybe his or her rights were terminated. So I do think that is a good change.
Yeah, I think it was one of those things that it just got lumped in there with regular adoptions where you really do need that evaluation. But people are having to pay money for something that was silly.
Right.
Like if I don't adopt them, they're still going to be in this environment. So what's
Right.
the point of it?
Right. Right.
It's not the same as a newborn adoption where we're looking, is this a good placement?
Right. Yeah.
You
It's
know?
already their reality. They're already
Right, it is their
living with the
placement.
step parent.
So what's the
Right.
point?
Right.
And wouldn't we rather have the step parent have legal obligations to that child?
Absolutely, we would. Yeah.
Make
No,
'em-
that was a good change. That
Make
was a
them
good
pay
idea.
some child support later. No, I'm not wishing divorce on those people.
But
I'm
that
not.
is the reality of the implications of that. That's true.
Right.
A duty to support.
Yeah, and then it doesn't fall on the state,
Right.
you know?
Right.
So that's good for all of us.
Yes.
Okay, so we're going to go into a more complicated area
Yes.
now. There's something called reimbursement. And maybe before we get into reimbursement, you can explain, how does law develop? And there's two different ways, and then that'll kind of tie us right into why
Sure.
are we talking about reimbursement?
Sure. So the legislature in Austin, of course, makes the statutes, makes the laws, the family law that we as family lawyers use that govern our divorce and child custody suits. The appellate courts interpret that law, and sometimes they interpret the law in ways that the legislature likes, and sometimes they interpret the laws in ways that the legislature doesn't like. And so when you have appellate courts that render opinions that the legislature likes, those opinions may become codified, become statutes in the actual Texas Family Code. And then they become the law of Texas and a lot easier to implement in our families.
And what's confusing, just to show why our job is difficult, is we have more than one line of appellate courts, right? We have
Right.
different districts.
It's regional.
And they do not have to agree.
No, they don't. So, for example, the Court of Appeals in Dallas might have a different interpretation of a statute than the Court of Appeals in El Paso. And what the El Paso court decided in one appellate case doesn't have to be followed by a Dallas court. Of course, the Texas Supreme Court needs to be followed throughout all of Texas. Any decisions made by the Texas Supreme Court need to be followed throughout all of Texas. But a lot of family law appeals don't make it all the way up there. So you have different appellate decisions in different regions of Texas. And when there is a problem like that, sometimes it's handled through the legislature to resolve that appellate split and have it codified in the Texas Family Code in a way that applies to the entire state, the way the legislature actually wants it to apply.
So we just had a big codification in reimbursement in the
Yes.
area of property division, confirmation in divorce cases.
Yes, we did in the reimbursement statute.
So explain what all that means.
Sure. So Texas is a community property state, and so that means that property that is acquired, obtained during the marriage, is going to be presumed to be community property that would be divided upon divorce. Okay. The Texas Constitution and the Texas Family Code, they do provide for separate property in Texas to be protected if you can prove by clear and convincing evidence that property you owned before marriage, property that you received by a gift or inheritance, those things are separate property not to be divided in a divorce. And so the reimbursement statute in the Family Code deals with reimbursing one estate, meaning the community estate, by a spouse's separate estate or vice versa, or technically one spouse's separate estate could owe a reimbursement claim to the other spouse's separate estate. So think of it as just shifting money around between the different types of estates depending upon the property that we're talking about. And so, for example, the best example to use here would be a house, okay? So say a couple gets married and one of the spouses already owns a home, and they decide to make that home their marital residence. Well, the home was owned before marriage, say by the wife, and it's therefore the wife's separate property. But during the marriage, there is a reduction in the mortgage principal that is paid by the community because both spouses' income during marriage would be community property. So the money that is being contributed by both spouses during the marriage to pay down the principal debt of wife who owned the house before marriage would create a reimbursement claim from wife's separate estate to the community estate, because the community conferred a benefit to wife's separate estate that the community does not receive a benefit from itself, because it's not the community's debt. And I know that's hyper technical, but that's the best example that I can give.
Okay, I'll say it back to you. So it's her house. She owned it before marriage. So the court cannot give that house to him. The court cannot make her sell that house. It's her separate property house.
Correct.
But they lived in that house for 7 years. And husband took his little paycheck every month and helped pay down that mortgage.
Correct.
So he's saying, wait a minute. I don't get anything out of that house. That isn't fair. I spent 7 years paying on that house. So this is the make it fair statute.
Right. That's exactly right. That's what this is all about. It is all about a fairness, equitable remedy for the estate that didn't receive a benefit during the marriage.
And this isn't a shall. This is a may.
That's correct. It's discretionary.
So the judge has the right to make it fair.
But doesn't have to.
But doesn't have to.
Right. That's true.
And what I like about that, even though it's frustrating if you're trying, you'd always like a shall if you're getting the dollar. But what I like about it is some of these circumstances are complicated. And there could be a lot of different fairnesses to be considered, not just that one fact pattern. There could be other things that happened in that marriage financially that the court could consider and weigh in deciding if they're going to recognize this claim or not.
Absolutely. And to that point, Melinda, there's this notion of offsets to reimbursement. So let's talk about that for a second, because if the husband helped to pay down the wife's debt on the mortgage, the wife could then say, but there's also an offset argument to be made in that we were maybe able to get more of a tax benefit by claiming the mortgage interest as a deduction, the real estate taxes that we paid,
you got to live there.
Right. Now, the real estate taxes are kind of tricky because, the community could argue that, wife's separate estate should have had to pay those, but then there's also the property tax deduction. So what's interesting about the new reimbursement statute is that they did codify some of the offsets, which would be income received. So if you had a rental property, for example, the rental income received from a separate property rental could be used as an offset, or the reduction in the amount of any income tax obligation based upon a deduction that you can claim. So just kind of a little interesting addition to the statute there.
This is where family law can get really complicated,
right,
because what you said at the beginning of that conversation was if you owned it prior to marriage, it's separate, or if during the marriage you received it by inheritance or gift. But in many cases, the income off of your separate property is community.
Correct.
So, and it's really almost item by item what the rule is about that.
Right.
Is the increase in value community or not? Or is it just the interest paid? Or is it the rental income? Or is it you cut the tree off the land? Or did the cow have a baby?
Right. Yeah. It depends on the type of asset to determine, whether the income is characterized as separate or community.
So this is one reason people need to hire lawyers.
Yes.
If they have any property and any complexity, it's not simple. All the time people come to me and say, so it's 50-50, right?
Nope. Just and right division, whatever that means.
And this is an illustration of why it's a just and right division, is there can be some of this complexity to sort it out.
Absolutely.
So people do need a little bit of assistance to sort all of that out.
Yes, they do. And absolutely, legal counsel is crucial, because I've seen too many times when people try to do the divorce themselves and then they have problems later down the road. Certain property wasn't divided as part of that divorce, or they have problems enforcing the property division. So if you get it right the first time, you're likely to have less problems down the road.
Yes. I have one right now where in the mediation, we went to mediation, got a binding agreement, but one of the things we said in there didn't really make sense. We thought it did at the time, but it's not doable. So sometimes we can all have a great idea. Hey, let's put a lien on that property to secure this. And then we find out that property's owned by a partnership or that property's owned by an LLC. You can't attach it effectively in the way we wanted to. So you have to not only sometimes have a family lawyer involved, but sometimes we have to hire experts in those fields, a real estate lawyer or somebody who understands division of qualified plans to help us, one, figure out what is allowed, what can we agree to, what can we ask a judge to do, and then to make it so.
Yeah, absolutely. I mean, you shouldn't hesitate to reach out to not just family lawyers, but accountants, CPAs, appraisers, whatever it may be for the particular issue, just to make sure that you're doing it the right way, because that's crucial.
Well, and I like that you said CPAs because there's a big tax effect on some things that people need to consider when they're considering, what do I want out of this deal? Is think about, are you taking an asset that hasn't been taxed yet?
Right, absolutely. Because I mean, you could be dealing with a significant tax liability, especially if the basis is pretty small, meaning that you didn't really pay much for the property to begin with.
Mm-hmm.
When you later sell that property, you could realize a substantial capital gain. And so, yeah, it's important to make sure that you have a team of professionals to help you make the good decisions for your benefit while you're going through this process.
Okay, so now to our next change to talk about in the law. And this affects lawyers more than the general public.
Yes, it does.
But we had a change in how we exchange information, which we call discovery.
Yes.
Tell us about that change.
So prior to this legislative update, we had what we called required initial disclosures, where we had to reveal or disclose certain information or documentation within 30 days of somebody filing an answer. So divorce petition is filed, somebody files an answer in response to the divorce petition. 30 days from that date, both parties are to exchange required initial disclosures, and it was mandatory. And if you didn't do it and you later had a hearing or a trial, the documents that you did not identify in your disclosures or did not produce in your disclosures would be excluded from being used as evidence. So it was oftentimes a trap, and especially affected people who were not, we were just talking about this, who were not represented by counsel, pro se parties, because they didn't know what the law was on this. And so now, in order to get that information and documentation, one party actually has to serve the request for disclosure, which provides notice now to the other party that he or she has to turn over certain information and documentation within 30 days of receiving that request.
So this initial disclosure, that it hadn't been around very long, that law.
No, maybe 2 years. Yeah.
So it didn't work. So sometimes the legislative session, they meet, they pass something, then they get so much feedback in the next session 2 years later that, hey, we don't like that.
Right.
We need to change it, that they will. So in this instance, they did a very special rule. Like, initial disclosure still applies in other areas of law.
It does.
But for us, it went away because it didn't really fit the family law model very well.
Right. And I think it just became kind of a gotcha trap that people were taking advantage of. And so now there's actually this notice requirement that, okay, now I know somebody's requesting this information and I have to turn it over within 30 days. And if I don't turn it over, then, okay, it makes sense that my evidence would be excluded because it was requested and it wasn't turned over.
What I like about repealing or taking away this initial disclosure requirement is it allows us to really look at each case and see, what do we need?
Yeah.
And sometimes a huge amount of the time in my cases, we just give each other what we need. We don't have to do a formal request anyway. But the initial disclosures required you to give certain things, whether you needed to really swap that information or not.
Right. Yeah. It was pretty time intensive. And
Yes.
so I think that this is going to allow people going through a divorce to save money, which is always great. So I think that this is the effect of that legislative change, is that we don't have to do this now.
Yes.
So I think it was a good change overall.
In 30 days, within 30 days, you almost had to have the entire theory of your case. The lawyer had to have already gathered everything that they might want to argue or use, and we weren't used to having that all done in 30 days.
No.
So I feel like by the time they repealed it, I'd kind of gotten used to it.
True. Yeah.
But I still agree that we're better off without it.
And I will say, I mean, it was helpful in those cases where, you represented somebody who might not have known much or anything about the assets. You didn't even have to request this information. The other side was required to produce it. So that was helpful. But now, like, if you need to know something, all you have to do is request it, and they have to turn it over.
I feel like it did, like, I can think of specific cases where I was really effective in a temporary hearing, just shutting the other side down because they hadn't provided it.
Yeah, absolutely.
And so it kind of lawyering, the case, it was kind of fun, but it wasn't fun if it was the other way.
Right.
If I hadn't provided something and then later in the case figured out, oh, I want to use this, then you were asking for leave to give something late, and it just increased the expense of everything.
It did. Yeah. It was a lot more paper pushing.
Yes.
Sure.
And if you look at it from a purely justice to be served, I mean, I do not think it's just for a pro se litigant to be able to put on no evidence at trial because they didn't know about this.
No, that's not right. They're not lawyers. They don't know, and maybe they can't afford an attorney. And so, yeah, that was a trap that I think pro se parties, especially to your point, we're taking advantage of.
And we have in our area of law more pro ses than probably most other areas.
We do. I mean, divorce and child custody affects all walks of life, you know.
So it was having a too heavy-handed of an approach. When the legislator meets, do they just sit around and say, what laws should we change? How does that work?
Well, there are committees and there are lobbyists, and lobbyists, of course, they lobby or try to persuade for the legislature to do something, make certain changes in the law. There's the Texas Family Law Foundation, which is comprised of Texas family lawyers and professionals who give their 2 cents about certain things they see working in the practice and certain things they don't see working in the practice. And the legislature, listens to them and also listens to others out there who, family law is affecting.
Yeah. So it's usually driven by something bad happened from someone's perspective, or something better could happen. And so people bring bills to the legislature and say, hey, I want to change the law in this way. And then they have people come testify and talk about why this is important change. And then they have other people come say, no, it wouldn't be good for it to work that way. So it's an interesting process. And the legislators, they're not family lawyers.
Right.
So they have to rely on, hearing from family lawyers on our perspective, but also the community and people who, think maybe they weren't treated fairly, or entities, like there's organizations out there that are trying to protect people. So on the protective order stuff, they have a good lens of, hey, we need something more robust. So because probably what happened on the protective order side, what we talked about at the beginning, is someone had some horrible thing happen to them but could not prove it was likely to happen in the future.
Right.
And that felt unjust.
Right.
And I can see how that would.
Absolutely. And then as a state legislator, somebody who is elected by the people, you probably don't want to be that legislator who says, I actually think that it should be harder to protect people.
Right.
So politically, that's how this probably got through.
Yes. So it'll be interesting to see how it plays out in the long run.
Yes, it will.
Thank you so much for being
Melinda.
here. This was fun to talk about.
Yes, it was great. Thank you so much for the opportunity. I really appreciate it.
We're going to put on the screen how to reach you. And
Great.
I highly recommend Robert. He is an excellent lawyer. You can tell just by listening today, he knows what he's talking about. So don't hesitate to reach out to Robert. He's representing people in the whole DFW area, true?
Yes, that's correct.
Okay, so his information will be on the screen. Now for the tip for the day. Our conversation today about law changes made me realize you really need somebody who knows what's going on. So, if you're considering a divorce or a modification of your prior order, I highly recommend hiring somebody who knows what's going on. You need a lawyer who spends most of their time doing family law, not someone who does a little bit of family law on the side. They're not going to spend the type of time typically digging into what did the legislature just do if it isn't a big part of their practice. So a good question to ask when you're interviewing is, what percentage of your practice is family law? And it's always good, whether you're hiring a lawyer or a doctor or anything, to maybe get a few opinions and ask each person, hey, who are 3 other people in your field that you think are excellent? That's just a good, easy way to find out who out there is good. And go with your gut. Trust your gut. And that is the tip for the day.